Thank you.
Mr. Hampton has entered into an agreement with the people, and would like to enter that into the record.
This case was supposed to be simple. A plea deal, 2 misdemeanor charges, a clean path into mental health court. But within minutes, it completely unravels. Brandon Hampton walks into court ready to plead guilty to aggravated assault and attempted resisting and obstructing. The agreement? Dismissed charges and entry into mental health court. But when the judge asks a routine question, has anyone threatened you? Everything changes. What happens next shocks the courtroom. The judge pauses the hearing. The plea is suddenly at risk, and one unexpected answer nearly blows up the entire deal. Was this confusion or a catastrophic mistake? Let's break it down.
Oh, sorry.
But I don't believe it's.
What? Okay. Talking about bonds.
All right, we'll just address this case today.
He's going to enter a plea in another case that's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Anne, right?
Yes.
You know Anne?
Yes.
Okay. So if you had this, that may work out where we could like get rid of 2 cases and he could plead. I may or may not do it, but usually just go over and ask Anne. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Anne.
Thank you very much, Your Honor.
You're welcome.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond and request that a condition, specifically the home confinement tether, be reconsidered.
Okay, I'll get to that maybe at some point.
Good, thank you. Yeah.
Right now, I'm trying to get these pleas done.
Thank you.
So my understanding is he's going to plead to count in case ending in 1596. He's going to plead to count 2.
Yes.
Correct? With count 1 being dismissed. That's going to be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, count 1, the resisting and obstructing would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement. May I have the defendant's sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Brandon Hampton.
Man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one, in the case ending in 1596, is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mm-hmm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it says the court, it's this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge
Oh,
Valvo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we we're just talking about with Judge Valvo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti or yes, in Ypsi City, it looks like. I'm sorry, Ann Arbor Township. Okay, so they occurred in two separate jurisdictions.
Okay.
Okay, that's why you have two separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay? You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to Valvo as well.
It will get there. It just can't go directly that way.
Okay.
Okay?
For sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay? All right. Any other questions you have?
Just the one about bond, but
Yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
yeah,
Okay. So to the charge of aggravated assault, how do you plead?
guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right. You signed an advice of rights form, correct?
Yeah.
Do you have any questions regarding any of those rights?
No.
All right. You see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes.
All right. Were you on probation at the time of these offenses?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
All right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
Oh,
Well, technically, you, Your Honor.
oh.
Mr. Hampton, so
Tell you what. Why don't we pass the matter? Maybe you can talk to him and we'll give this another shot today if we're comfortable with it. Otherwise, the court may not be comfortable with it, and we might just blow all of this up and it'll just have to happen another way.
thank you.
But I'll give you a chance to talk.
We appreciate that.
All right. We're back on the record in the case of the people versus Hampton. We're in the middle of taking a plea. And so I stated the terms on the record. And Mr. Hampton, I'm going to ask you a couple questions again.
And this right here is the moment the entire plea deal almost collapses. When a judge asks whether anyone threatened or coerced a defendant into pleading guilty, that question isn't casual. It's constitutionally required. A plea must be voluntary. If there's even a hint of pressure, intimidation, or coercion, the court cannot legally accept it. So when Mr. Hampton says, well, technically Your Honor, that's explosive. From a legal standpoint, that statement signals possible coercion, even if he didn't mean it that way. The judge now has to pause everything, because if the plea isn't voluntary, it's invalid. And if it's invalid, the entire agreement, including mental health court, falls apart. Notice the judge's reaction. Calm, controlled, but very clear. We might just blow all of this up. That's not a threat. That's legal reality. And here's the bigger issue. When Hampton later describes the incident, he frames himself as defending his life. But he's pleading guilty to aggravated assault. That contradiction makes it legally impossible for the judge to accept the plea as stated. This is why judges slow things down. A plea isn't just paperwork. It's an admission under oath. If the facts don't support the charge, the court cannot accept it. So now the deal is paused. The plea is unstable. And what should have been a routine resolution turns into a procedural reset. Here's the question for you. Do you think Hampton misunderstood the judge's question, or did he genuinely feel pressured by the situation? Let me know in the comments.
And then broke in my property.
Okay, but before that, did you do anything before that?
No,
Okay.
it wasn't until there were 4 people on top of me and I was fearing for my life that I bid him here.
Okay, so here's what I'll do. Counsel, because I can see the way that this plea's going, it's not gonna work. So if you guys want to change, I'm not suggesting you guys want to change things to a no contest. If you want to do whatever, what I will do is I'm back up at 1. I'll call it back up at 1. I think everybody's still going to be here. So, and give you a chance to talk with him, decide whether or not you want to do no contest, please explain what a no contest, go through all of that with him, and then see if we can get this done.
Thank you very, very much, Your Honor. Appreciate it. Thank you.
This is a prime example for me of no good deed goes unpunished. All right, so we'll call it back up at that point. Quarter past these matters again. All right.
We actually, based on the most recent conversation with my client, I will actually seek to adjourn this case for to further advise my client on the offer.
All right.
For the shortest adjournment possible.
February 13th. Both matters.
Thank you very much, Your Honor.
Both matters? I don't have to come on.
Well, that's true. What are we doing with, well, when is the exam set?
Tuesday.
Yes, so apologies. We can see, I'd be happy to stip to adjourn that, the exam or for the other case.
Well, you're gonna need a step on the exam.
Yes.
But I only took it because there was gonna be a plea. When do you want the other one adjourned to?
When is the soonest?
I'll set this, I'll adjourn the
After the
1596. I'll adjourn 1596 to February 6th. The other one is stay on track for a preliminary examination. I understand that people are not going to have the witnesses available, or you need a stipulation to adjourn that out.
Thank you.
Okay.
Thank you, Your Honor.
And we're going to have to clarify this.